చేయాలి. అదేంటిది? ఓకే, రైట్. సార్ లైవ్లో సార్ ఎవరు లైవ్? గో హెడ్. మీరు లైవ్లో ఉన్నారు, గో హెడ్.
సరే సార్, అది కవర్
సార్ ఎవరు లైవ్?
Good evening to all of you. Today's topic is law of bailment, that is dealt with from section 148 to 181 of the Contracts Act. This is also the second species of specific contracts. First and foremost is bailment arises in everyone's life someday or the other. Well, someday we have a marriage function, someday we have a crediting function, someday we have anniversary, sometimes we have engagement function, or sometimes we have a get-together party, and so on and so forth. Please remember, you cannot expect to have everything in your house. You don't expect that there should be a crockery, or the crockery should be available, spoons should be available, glasses should be available, drinking water should be available, or shamiana should be available, or let us say the carpet also should be available. So for that, we approach a tent house and book our goods and tell him, sir, I want it for a particular function. In my house, there's a function for 2 days or 3 days, and you must erect the shamiana, as well as also give me the crockery, as well as the other bagona and all, which is used for cooking purposes. So, on the agreed consideration, the person who is running a tent house hires those articles to you, and then with a specific condition that you should pay a particular sum of money for the purpose of hiring, and also return it as soon as the purpose is accomplished. And once the purpose is accomplished, you will have to return the goods in the same condition as it was when it was delivered to you. So the crux of the law of bailment is temporary possession of the goods is delivered by a person called the bailor to a person called the bailee on the consideration of payment of higher charges, and also subject to a superadded condition that the goods will be returned to the bailor as soon as the purpose is accomplished on payment of the higher charges and return of the articles that has been taken by you by way of hire. This is called a law of bailment. It arises in our day-to-day life. And please remember, if someday or the other, for some function or the other, you require the help of a tent house. And here, the tent house person or the owner of the tent house parts with the possession of the goods for a temporary purpose and hands it over. Possession of the goods are handed over to a person called the bailee on the consideration of payment of higher charges, and also subject to a superadded condition that the goods will have to be returned back once the purpose is accomplished, and also that the goods will have to be returned back in the same condition as it was when the possession was delivered. In other words, what is delivered is only possession, and that too for a temporary purpose. And what is not delivered is ownership. As far as the ownership is concerned, it remains with the bailor, and because every contract has to be supported by consideration, the amount what you pay towards the higher charges, or the amount what you pay for a particular duration of time when you require the articles belonging to the tent house keeper or to the bailor. You also say that once my function is over, I will return back all the goods. And please remember, at the time of returning, the bailor will inspect all the goods, count all the glasses which are given, or let us say the bagonas which are given, the spoons which are given, or the what is called the cooking utensils which are given, and the tent which is given, or the what is called the carpet which is given, so on and so forth. So the question is, the bailee does not become the owner of the goods as far as the contract of bailment is concerned, he comes into temporary possession of the goods with a superadded condition that he must pay the higher charges, and once the purpose is accomplished, the goods will have to be returned. So, what is important in a contract of bailment is the element of return. Though possession is delivered, ownership remains with the bailor. So, this in our real practice, real day to day life, we experience it whether you like it or not. When there's a function in your house, and we all resort to what is called bailment. Sometimes what happens is a hirer also hires, gives it to you on hire, the furniture, the fridge, or he gives you the mixie, so on and so forth, for a temporary duration of time, and so as and then also charges the higher charges, and the higher charges will have to be paid. And once the purpose is accomplished or the period for which the goods are taken, you will have to return it back. So the element of return is a prime criteria as far as the law of bailment is concerned. Is it clear to you, please? Then we come to the subject in the proper perspective, that to say bailment is a legal arrangement where a person, the bailor, transfers possession of his property to another person called the bailee for a specified duration of time, uh, on payment of higher charges, and also retaining ownership of the property, and the bailee is responsible for the property during that time, and otherwise, uh, that is, it is said, but does not own it. So the question of element of ownership, element of proprietorship, element of title, as far as the goods are concerned, remains with the bailor, and you only come into temporary possession of the property, and for a specific duration of time, and you'll also have to pay the higher charges for whatever goods you have taken on hire. And the consideration as far as the bailor is concerned, parting with the possession of the goods is a consideration for hiring, and as far as the bailee is concerned, the consideration is payment of the higher charges, and also the added responsibility that once the purpose is accomplished, the goods will have to be returned back. Please underline the word element of return. But please remember, in a contract of bailment, ownership remains with the bailor. The bailee does not become the owner of the property. Are you able to understand, please? So, as far as bailment is concerned, it arises mostly in cases of movable property, not regarding immovable property. Immovable property, I've already discussed. I think you know about it. We discussed the law of leases, where you take a house on rent, where you take a shop on rent, or when you pay the rent every month. That is as far as immovable property is concerned. But as far as movable property is concerned, it is covered by the law of bailment. So, what is delivered in the law of bailment is possession of the goods is delivered, and under the consideration that the higher charges will have to be paid by the bailee, and the bailee comes into temporary possession of the goods, and the element of return is there. Once the purpose is accomplished, the question of the bailee has to return the goods, but the ownership still remains with the bailor, and the bailee does not become the owner of the possessed goods. Here, going further, sir, types of bailment: deposit, loan for use, or are gratuitous. That is, deposit. What do you mean by deposit? Sir, most of us go to Tirupati, most of us go to Kanakadurga temple in Vijayawada, we go to all the holy places. There you have got a dormitory, or there is a locker kept and maintained by the Devasthanam authorities. Suppose you don't get accommodation, what you do is you keep all your valuables inside the locker. They give you a lock and key, and they also take a deposit from you. And as soon as your purpose is over, your visit is over to the temple, your darshan is over, you have got a right of taking back the articles from the locker, and then hand over the keys to the person who is the operator as far as the locker is concerned. But you have to first deposit 200 rupees or 300 rupees towards the higher charges. But once you return the keys, you are entitled to get back that, because all lockers within the sanctum sanctorum of the temple, or within the jurisdiction of the devasthanam is supposed to be free. But the question is, the question is that you have to hand over pay a deposit, and once you finish your darshan and your darshan is over, the visit to the temple is over, you can surrender the keys and then take back the deposit what you have paid. Deposit is anama. That is, the question is, the person who operates the locker must know that it has been given for a particular purpose. And in some places they charge for lockers. But then you go to the case of a banker. In banks, most of the banks, what they do is they have locker system. They have the locker facility. The locker facility is you can keep your valuables like gold, silver, and your ornaments in the locker, and then operate the locker, and then you pay the higher charges of the rental. As far as the locker is concerned, they collect it every quarter, every half year, or every 1 year. But please remember, now banks have made it a business. What they have done is, and outside you see, say a deposit lockers available. That means they don't give it to you free of cost. Don't be under the impression that you get it free of cost. They say at least you must give a fixed deposit of 1 lakh or 2 lakhs so that the locker is given to you. Of course, you've got locker of different sizes. The locker of different sizes according to your choice and according to your requirement, you operate the locker, and the locker is given to you with a particular number and with a particular key. And please remember, if you see the locker, it is double key rather. The locker will not open unless the official of the bank comes with you and he operates the first key, and then you operate the second key, and only when both the keys are applied, the locker will open. And please remember, you need not disclose what you have kept it in the locker, whether they are valuables, whether they are gold, whether they are silver, whether they are valuables according to you. And please remember, no one asks you what you are keeping inside. But for that, you are charged. That is, a rental is charged for letting out or giving on hire a locker kept and maintained by the bank. This is done this is done for charges. But as far as the temple authorities are concerned, where the lockers are kept with by under the control of the Devasthanam people, you pay the deposit and then keep all your articles inside. And once you finish the darshan and come back, you can take it back. And then once you surrender the receipt, you get back the deposit what you have paid. This is adopted by most of the religious institutions. I still remember I am one of the members of the Sahaj Marg, that is the Ramchandra mission. There also in the what is called the in Kuttur, you have got a very big mutt, very got the there also you have got dormitory accommodation. And suppose you are an abhyasi or a disciple, what they do is they give you a locker in which you can keep your valuables, and then you will have to deposit 500 rupees as security deposit. And once you return the pillow, return the return the bed sheets which are given to you, or the blankets that are given to you, that 500 rupees is returned back to you. Please remember, lockers are operated almost with the financial institutions or various institutions. Then you have got the safe deposit vaults. Safe deposit vault, there is a subtle distinction between a locker and a safe deposit vaults. There are some companies which run this business of safe deposit vaults. Your valuables it's almost a locker. You keep your valuables inside, keep it locked, and it is operated with two keys. And unless both the keys are applied, the safe deposit vault does not open. So that is also a form of bailment, where you can keep it forever. Of course, the distinction is it is not for a specified duration of time. You can keep your valuables for any length of time, provided you pay the rentals, and the person who is running the bank which is running the lockers or the safe deposit vaults, they get the higher charges as far as the locker is concerned. And nowadays they're not charging higher charges. What they are doing is they are asking you to give a fixed deposit, so that the interest which accrues from the fixed deposit, that is appropriated towards the rental as far as the locker or the safe deposit vault is concerned. So this is also one form of bailment. Then you have got what is called uh, gratuitous bailment, where someone gives a coat to an attendant at a theater. This is an example of gratuitous bailment. Here, sometimes what happens is your neighbor, because you are going to attend and please remember, this is very, very common in ladies. వాట్ ఎ లేడీ డస్ ఇస్ అంటే పొరుగింట్లో పోయి అడుగుతారనమాట. అమ్మ మీ దగ్గర ఏదైనా మంచి పట్టు చీరలు ఉందా, మంచి చైన్ ఉందా, మంచి నెక్లెస్ ఉందా, ఆర్ మంచి గాజులు ఉందా అని. సో దట్ అనదర్ లేడీ విత్ whom you are friendly, you means your wife is friendly. She gives that jewels and the saree also, pattu saree, to be worn for a function. Please remember, though she gives the pattu saree or the silk saree or the jewels for wearing and attending a function, the person who receives it, he does not become the owner of those goods. What she has to do is, once she attends the function and comes back, honestly and sincerely, she must return it back to the person from whom it is obtained. Then it is not free of cost. No one charges for hiring a sari, or no one charges a lady for the purpose of lending a sari for the purpose of wearing and attending a marriage function or a reception or so on and so forth. The good neighborly relations are maintained by each other. Then the question is, it is called a gratuitous payment because it is free of cost and no money is charged. But there is a super added condition that once the purpose is over, you will have to restore back the possession of the goods which you have taken from your neighbor. This is called a gratuitous bailment. One is a locker facility, the second one is gratuitous payment, and another is deposit. Deposit is, suppose I told you also, cloakroom, where you, even in a railway or even if you go to a bus stand or a main bus stand, you have got the lockers there. You deposit your luggage and in the cloakroom and you pay the higher charges. And once you finish your job, you can take it back and then go home. Please remember, the person who takes it on deposit does not become the owner of the goods, but he only becomes a temporary possessor of the property. At the most, he can be called as a bailar, and you as a person, I mean, he's called a bailee, and you as a person who has handed over the goods for safe deposit is called the bailar. And there also, the element of return is involved. So. Then difference between bailment and leasing. Here, what is the basic difference between a bailment and leasing? Here, in the case of bailment, movable property is handed, possession of movable property is handed over by the bailer to the bailee on consideration of payment of higher charges for a specified duration of time, and also with the subject to a super added condition that once the purpose is accomplished, the goods will have to be returned back to the bailer in the same condition as it was, subject to reasonable wear and tear. And the question is, the bailer retains ownership over the goods, and you as the bailee, you come into temporary possession of the goods. You are only possessor of the goods, and that too for a limited duration of time. And once the purpose is accomplished, you will have to return. But in a contract of lease, also lease is అంటే కిరాయికి తీసుకోవడం, అద్దెకు తీసుకోవడం. That is called leasing. Here, suppose let us say I go and transfer to Guntur. I cannot own a property at that place. Then I take a house on rent, and then for a specified duration of time, 11 months or 1 year or 2 years or whatever it is, as the case may be, and the rental is fixed. And once the rental is fixed, and for that period for which it is let out, I can remain in possession of the property. I become only the possessor of the property. In a contract of lease, what is the lease? That is lease depends upon the immovable property. What is delivered to you is only possession of the immovable property, and on the consideration of payment of rent, share of crops, annuity, so on and so forth, by the lessor to a person called the lessee for a specified duration of time, and on consideration of payment of rent, etc., etc., and subject to surrendering or handing over possession of the property to the lessor after the lease has come to an end. But please remember, in bailment, it is movable property. But as far as lease is concerned, it is supposed to be immovable property. Here also the element of return is involved. But the only difference between bailment and leasing is that bailment involves movable property, but as far as leases are concerned, it covers immovable property. So, what is common in both of them? Possession is delivered for a specified duration of time on payment of rent, share of crops, annuities, so on and so forth, and also subject to a superadded condition that once the period of tenancy or lease comes to an end, the possession of the property has to be delivered back to the lessor, and the lessor remains the owner of the property. You become only the possessor of the property. So that is the basic distinction. In bailment, it is movable property. In leasing, it is immobile property. In both of them, right to possession of property is delivered. In the case of bailment, it is right to possession of goods. Here, and I consider, because every contract has to be supported by consideration, what you pay in bailment is higher charges. And also, the superadded condition is it is given for a specified duration of time, and once the purpose is accomplished, the goods will have to be returned. But the ownership remains with the bailor. But as far as lease is concerned, possession of immobile property is delivered by a lessor to a person called the lessee for a specified duration of time on the consideration of payment of rent, share of crops, annuities, or profits arising out of a business. It is a cause, and also subject to once the period comes to an end, you have to surrender possession back to the lessor, and the lessor remains the owner of the property, and under no circumstances the lessee becomes the owner of the property. That is the distinction between a bailment and a lease. Then next distinction is distinction between bailment and pledge or pawn, whatever you may call. As far as bailment is concerned, temporary possession of goods is delivered by a person called the bailor to a person called the bailee on the consideration of payment of higher charges for a specified duration of time. And once the purpose is accomplished, the goods will have to be returned back to the bailor, but the title remains with the bailor. But as far as pledge is concerned, pledge or pawn, as you may call it, or what is called kudu ular, what the rehen, we call it in India as rehen. That is where movable property is offered as security for the purpose of securing a loan or securing a pecuniary liability which is paid, promised, so on and so forth. Here, mostly this cases of pledge or pawn arises regarding gold ornaments, gold loans. Suppose, let us say, you got gold with you. You want money for business purpose. Then you go to a pawnbroker or you go to a bank and then offer your jewels as a security for due repayment of the loan. Such a transaction is called a pledge, and the person to whom the property is pledged is called the or pawned is called the pawnee, and the transaction is called a transaction of pawn or transaction of pledge. Please here also you remember that the pawner only becomes the pawnee only becomes the possessor of the goods. He is not the owner of the goods. The ownership, as far as the goods are concerned, remains with the Pana, and Pani only comes into possession of the goods as a security for the performance of a pecuniary obligation. And once the obligation is completed, the entire loan is paid. The goods will have to be returned. The possession of the goods has to be returned back to the person who has pledged it, or what is called the panar. And that transaction is called a pledge, or it is called a pawn. So, bailment and pledge almost are similar because their similarity arises only in the case of element of return. But the question is, as far as pledge or pawn is concerned, it is only what is called to secure a pecuniary liability, a money liability, or a loan which has been advanced on the strength of the security of the jewels that have been furnished, that has been deposited, and the question is the pawnee only comes into possession of the goods. He keeps it as a security to see that the pawner makes the payment, and once the payment is made, the question of pawnee retaining the goods, keeping the goods, becoming the owner of the goods does not arise. And this arises mostly in respect of gold loans. So what is common between bailment and pledge, sir? common between bailment and pledge is the element of return. Are you able to understand? Then we go to uh, here. One minute. Here, as far as pledge is concerned, pledge is defined as where possession of goods is delivered by a person called the pawnee to the pawnee to as a security for the due repayment of the loan, and the pawnee comes into possession of the goods, and it is only held as a security. And once the entire loan is paid, he has to return back the jewels or return back the goods to the pawnee concerned. And please remember, under no circumstances the pawnee becomes the owner. Ownership remains with the pawnee. Then, sir, if a plaintiff they can sue for damages based on the duty of care. They can also sue for conversion, which is considered as an older type of damage. Yes, sir. What is the remedy open, sir? Suppose the goods are not returned. Suppose the contract of bailment is not kept up. There is a violation of the contract of bailment, whereby the bailee refuses to hand over the goods to the bailor. What is the remedy open to the bailor, sir? The bailor can sue for damages for the or compensation for the goods not returned, or where the possession is not handed over back to the bailor. Here it is said he can sue for damages and also for damages based on the duty of care. Suppose, let us say, you are not the person, the bailor does not be, the question is, the bailor does not become the possessor of the goods. He parts with the possession. Who has to take care? The care has to be taken who comes into possession of the goods. And suppose he does not take care and he does not act with due diligence as a prudent businessman, he can be held liable for damages by the bailor. And the next aspect is as far as the goods are damaged, deteriorated, or then in that case, whatever damage has occurred, that can be recovered from the bailee by the bailor. Then next is conversion. What do you mean by conversion? Please remember, once the goods do not belong to you, you become very, very philanthropic. You become very, very generous. You become very, very charitable. Then the question is, suppose the goods belong to the bailor, and then you convert those goods with your own goods, and then you cannot make out which is your goods and which is the goods of the bailor. Then in that case, whatever damage has occurred to the bailor as a result of your violation of the contract of bailment, the bailor is entitled to recover damages from you as a bailee. Then, sir, a bailment, the delivery of goods by one person to another for some purpose upon a contract that they shall be returned or otherwise disposed of according to the person delivering them. Here, the element of return is absolutely a must. It's a sine qua non for the contract of bailment regarding movable property. As far as immovable property is concerned, the element of return is also there. When does the element of return come? As far as immovable property is concerned, in the law of lease, it comes into operation once the period for which it is leased or period for which it is let out comes to an end. You have no business to stay on to the premises and hang on to the premises and then say refuse to hand over possession. It is almost the same, but bailment deals with movable property, but this deals with immobile property. And please remember, both what is common is you come into temporary possession of the property. Ownership still remains with the owner. You do not become the owner of it. The element of return is there in bailment also. Once your function is over, the purpose for which you have taken the goods is over, you have to return it. And as far as leases is concerned, once the period mentioned in the lease deed has come to an end, you have to return back the possession of the property. And in both the cases, the bailor still continues to be the owner. And in the case of lease, the lessor continues to be the owner. And in both the cases, the bailee or the lessee does not become the owner. And the question is, the elemental care has to be taken both by the bailee as well as the lessee to see that the property is not damaged, property is not spoiled, no structural changes are made, or the question is, you do not go contrary to the terms of the lease or terms of the bailment. Then the loaning of Soam's item is the bailer and bailee as one of the types of bailment. If one parks a car at the parking slot, the car owner and the lot owner both benefit. That is, it is under the exchange of goods and services. You go to the bus stations, you go to the airport, you go to the railway station, or you go to various places. Parking charges are levied, isn't it? That parking charges which is levied is in exchange, is a consideration for allowing your car to be parked at the parking slot, kept and operated by the parking slot owner. And the parking slot owner gets benefited because for every hour of parking, he gets the parking charges. And as far as you are concerned, as a car owner is concerned, you can be rest assured that your car will be safe and secure because it is under the care and supervision of the slot owner. So in both the cases, the slot owner, the parking contractor, and you as the owner of the car both get benefited because you get a place where you can park your vehicle, and the person who operates that slot gets his remuneration by way of parking charges which are collected. Then, sir, bailment allows individuals to transfer possession of their property to someone else for safekeeping. Banks have, that is, the secure means when it comes to holding assets. Here, banks also give you lot of facilities, sir. Have a locker facility. You've got a safe deposit ward. You've got or even if you go to holy places, you've got the locker which is given to you on hire, and for that temporary period, then you pay the deposit. Or as far as bank lockers are concerned, you pay the annual rental that is levied, and the bank gets benefited because it gets the rentals, and you get benefited because you keep your valuables in the locker for safekeeping, which is safe and secure, and it's free from any eventuality. Then, what are the types of bailment? Here, service agreement. Service agreement means if you if you see the metro stations, there's a particular area earmarked for parking of scooters, cars, and automobiles. As far as a person, actually, when the metro rail came, they offered it free of cost. Please remember, now nothing is free of cost. Hey, question is, you have, and please remember, I've seen the system in Bombay, seen the system in Chennai, in big cities, including Hyderabad. A person has to daily commute to and fro from high-tech city or Gachibowli, go to a metro station, park his car, park his scooter, park his motorbike, and then he comes back in the evening, then collects his vehicle. And please remember, there is a service agreement between you and that operator of that parking slot that you pay every month or you pay every day. And please remember, the person who operates the slot benefits in the form of parking charges, and you as a car owner or vehicle owner gets benefited by having a place where you can safely park your vehicle. Then, sir, the rights and duties. Please remember, here it is vice versa. Rights of a bailer is a duty of the bailee. The duties of the bailer is the rights of the bailee. Here, bailer is responsible for the in the event of risk of goods, that is deterioration or destruction of the goods, unless he takes reasonable care to protect them. So as far as contract of bailment is concerned, the duty of the bailer is to take care of the the rights of the bailer is to take care of the goods and then keep it in safe custody and also return it back once the purpose is over. Here, bailee is responsible for taking care of the goods while returning and delivery any profits from the goods to the bailer. Sometimes what happens is, suppose a bailment is done where a cow is handed over to you on bailment, and suppose, let us say, the cow gives birth to a calf. Whatever accretions arise, whatever additions arise after the bailment, when the bailment is in operation, the person who was hired or was handed over possession of the cow to you is also entitled to the calf. You cannot say, sir, I'll hand over only the cow to you because what was given to me was only the cow. Knowingly or unknowingly, fortunately or unfortunately, the cow has given birth to a child. That calf belongs to me. You cannot make business over possession of the goods. Whatever accretions arise, whatever profits arise, whatever you get from that by way of milking, so on and so forth, you will have to hand it. You will have to give a percentage of it to the bailer. Then, sir, the contract terms, that is, are documentary and may include, that is, it may involve consideration. Or, see, please remember, nowhere it is said that a contract of bailment has to be reduced to writing. No. If you go to a tent house, only the printed receipt which is given to you, the goods which are handed over to you, the goods which are given, and the respective charges alone are mentioned, and no documentation is done. It can be done orally or it can be done in writing also, but the slip which is given to you, the articles which are given to you on bailment, those lists will be there, and according to the list, the goods will have to be returned. Then kinds of deposit, delivery of goods to another for use, for accommodation. Accommodation means lent to the friend gratuitously to be used by him. I told you first one is deposit, delivery of goods to another for use. Suppose, let us say, the first one is deposit. Suppose it is given as a deposit or to keep it in safe custody, like a safe deposit vault or a locker. There the contract of bailment arises. Then second case is where the delivery of goods to another for use. Suppose, let us say, your furniture, your dining table, your chairs, dining chairs, or your fridge, or your mixie, it is given to you on hire, and the possession of it is given to you, subject to the condition that you pay the higher charges. It is given to you for 1 month or 2 months, and once the purpose is accomplished, the goods will have to be returned back. Then accommodation means that is lent to a friend gratuitously to be used by him. Suppose I told you also this arises mostly in the case of ladies. Suppose a lady is going for a marriage, then she does not have a pattu saree with her or a silk saree with her. Then she goes to her neighbor and say, నీ దగ్గర మంచి చీర ఉంటేవమ్మా, పట్టు చీర ఉంటేవు, ఇవాళ నేను ఒక ఇది పెళ్లికి పోయేది ఉంది, నేను వచ్చిన తర్వాత నీకు ఇది తిరిగి ఇచ్చేస్తాను. Or you got a gold necklace or bracelet or whatever it is. That is, and you have a good Samaritan as your neighbor. She obliges you for everything. Then she hands over temporary possession of her jewels, a necklace, so on and so forth, or the silk saree for the purpose of attending a marriage function or any function. Then once the function is over, you will have to return it back to the person from whom you have taken. It's a gratuitous bailment. Gratuitous means no money is paid for hiring. Are you able to understand this? But please remember, nowadays nothing is available to you free of cost. But unfortunately, till that feeling has not come among ladies. But as far as I've seen temples, where in some temples you are not supposed to go with jean pants or shorts and T-banian. Dhotis are available. What is called the Angavastram also is available on hire. You pay a particular sum of money towards higher charges, and once you finish the darshan, you can hand it over to the person from whom you have taken. But for the purpose of giving possession of that, he charges money from you. Then that is also a form of payment. It is not gratuitous, please. It is not held free of cost. Even a parking slot is not given to you free of cost. You have to pay for the higher charges, or you have to pay for the parking charges, or for that particular slot being given to you for a particular duration of time. You have to pay the parking charges at any cost. And please remember, without paying your parking charges, you cannot take back your vehicle. Then, bailment may also arise in the case of a tailor. Suppose, let us say, I want to get a safari suit stitched. I give my measurements, I give the cloth, and ask the tailor to stitch it. And then the tailor will stitch it, keep it ready for delivery. But he comes into possession of the cloth given by you, which is converted into a finished product by stitching a safari suit for you. But he is entitled for the tailoring charges or the labor charges, which you are supposed to pay. Till such time you pay the labor charges, you will not give delivery of that particular suit to you. Why? Because a tailor lives on this particular trade. Then pawn or pledge deposit as security. As I gave you the distinction between a pawn and a bailment. In a pawn, mobile property is offered as a possession of mobile property is offered as security for the purpose of a pecuniary liability, and the temporary possession of the goods is handed over by the pawner to the pawnee as a security, and then the pawner is liable to pay the interest accruing in respect of that loan until such time the interest is completely liquidated, the principal amount is paid, the pawnee is under no liability to return back the goods. And though the goods are possession of the goods are handed over, the pawnee does not become the owner of the goods. So ownership still remains with the pawner, but subject to a superadded condition that the loan amount and the interest will have to be paid from time to time. Then delivery for transportation for reward. Delivery for transportation for reward. What do you mean by delivery for that is delivery for transportation for reward. Here, for example, please remember a dealer in Rajamandri has to supply you rice, 500 bags of rice. You are a person in Hyderabad. Then what happens is the trader there in Rajamandri will not carry it on his head. He engages the services of a carrier for transporting the goods from one place to another, and for that purpose, the owner of the goods has to pay transportation charges, and that is collected from the person who is going to be the recipient as far as the goods are concerned, and that is called freight. Then delivery without rewards. Please remember, this is all Harishchandra's time. No one deliver anything from one place to another without reward being paid. For example, suppose you want to hand over some goods to a courier for the purpose of being carried from one place to another, you have to pay the necessary charges. So please remember, this delivery without rewards may not arise in real practice. Then duties and rights of bailer. Then, as far as the bailer is concerned, he must disclose defects known, and facts in the. If not, he is responsible. He is responsible. Here, please remember defects. As far as the defects in the goods that are bailed, the bailer is responsible to disclose all the defects. For example, I can take you a case where a horse is where the possession of a horse is given by a person called the bailer to a person called the bailey, and at the time of hiring, the bailer tells the bailey the horse is in a very good condition. It can run 100 kilometers per hour, and it is fit for what is called equestrian sport or for riding. But ultimately, it turns out that the horse is vicious, is dangerous, and also and also not ride worthy. Please remember, even in horses, you've got the different categories. Some horses are meant only for racing. Some horses are meant only for as a used as a Tonga or a Victoria, or it can be used only for that is called jumping, so on and so forth, or for equestrian sports. Please remember, suppose let us say horse is given on hire, and the owner, that is a person who hands over the horse to another person in a contract of bailment, knows the vicious qualities of the horse but does not disclose it. The person who suffers injuries as a result of the hostile nature of the horse can sue the person who has given it on hire to him under the contract of bailment and ask for damages. Then uh, A lands a carriage which is unsafe and A is liable for damages. Suppose, let us say, a contract carriage is delivered to you. Let us say, what you call it as tempos and so on and so forth. That does not have proper tires. The engine is not proper, and at any time it may meet with an accident. At any time it may have a collision, and these facts are known only to the person who gives it to you on bailment, hands over possession of those goods, which is not it is not safe to run that carriage, and ultimately it turns out to be defective. It meets with an accident, and the person who has suffered an accident as a result of non-disclosure of these facts can sue the person who has handed over that particular carriage without disclosing these facts. Then next one is A gives a car to C without B's knowledge and permission. Here, what happens is naturally, sir, the love and affection which the husband has got for the wife or the wife has got for the husband is something very, very common, sir. Though they may be having an hostile attitude at home, but please remember there is no person who does not love his wife. Then what happens is a friend of B delivers a car to his friend A on the condition that it is only meant for use of A. But who has to use the car, sir? It has to be used only by A. But what A does is, on a busy road, he gives a steering to his wife to drive the car, and the wife drives the car in a rash and negligent manner, and which results in an accident. Here, as far as the cost of repairs, cost of damage which is caused, A is bound to compensate the person who has given the car for his personal use. Why? Because the person has acted contrary to the terms of the bailment. The next one is uh, in case of a gratuitous bailment, regarding this is section 158, please. Regarding a bailment in the absence of a contract to the contra, the bailor must repay to the bailey all the expenses incurred by the bailey for the purpose of bailment. Here, sometimes what happens is the car or the vehicle which is given on bailment, certain repairs have to be done. Engine has to be overhauled. Engine has to be opened. Then some parts have to be replaced. The tires have to be replaced. All these faults were not disclosed by the bailor to the bailey at the time when the contract of bailment is entered into. So whatever expenditure is incurred by the bailey for the purpose in this regard, it has to be compensated by the bailor when he takes delivery of the vehicle. Then next one, sir. In case of non-gratuitous bailment, the bailor is responsible for the extraordinary expenses. The extraordinary expenses. That is, suppose the vehicle minor repairs is okay, but extraordinary expenses are involved where the bailey is made to spend for that. Whatever money he has spent, he is entitled to be reimbursed by way of damages by the bailor, and he has to pay. Then here, uh, but the question is, the expenses for petrol, toll gate charges, and all has to be made by the person who has taken it on hire. But as far as extraordinary expenses are incurred, the bailor has to compensate the bailey. Then what are the duties of a bailey, sir? Please remember, అది ఎవరిదో సొమ్ము నాకేం పట్టింది ఏమన్నా కానీ అంటారు. No, you must take care of the goods, keep it in a proper condition, see that it is not stolen, see that no parts are missing, see that it is handed over in the same condition as it was given to you. As a prudent businessman who would take care of his own goods, such element of care is required in a contract of bailment. The second one is no unauthorized use. Here, the next one is that is 155 to 157. not to mix goods with his own goods. Here, suppose let us say A in a contract of bailment hands over 100 bales of cotton of a superior variety. It is a duty of the bailee not to mix up that 100 bales of cotton of that fixed quality with his own goods. And if he does it, he commits a breach of the contract of bailment. Then, in that particular case, whatever expenses are incurred for the purpose of separating the goods of the bailer and the goods of the bailee, those expenses will have to be borne by the bailee if he converts his goods with the goods of the bailer. Then second one is if the goods cannot be separated for any reason, then in that case the question is, it is said not that is to another claim to the bailee shall not set up adverse tax. Then next is if it cannot be separated, whatever damage accrues to the bailer, that has to be compensated by the bailee. And the third one is that he shall see. Remember, I think I remember a story in my young days. A fight between two cats. The monkey gets benefited. The question is, who has given you the goods, sir? The goods has been bailed to you by the bailer. What is your responsibility? You must take care of the goods. You must exhibit all care and caution. You must take care of it as if it is your own goods. You shall not convert it. You shall not make unauthorized use of it. But if you set up adverse title in a third person and say, I am not going to hand over the goods to you, I will hand over the goods only to the third person who has got title to the goods and not you. Please remember the doctrine of promissory estoppel says, even if a person's defective title has handed over possession, it is your duty to hand over the goods back to the person with a defective title. What dispute he has got with the neighbor, what rival claims are there, you are not concerned with that. But once you set up adverse title in a third person, you become liable for violating the terms of the bailment. Then we go to section 160, return the goods without demand. So, as a gentleman, when possession of goods has been handed over to you, it is your duty, sir, pay the higher charges regularly. And also, once the purpose is accomplished, once the purpose is over, you must return the goods back to the bailer. And please remember, this is a fundamental duty which every bailee has to perform. With one more section, I shall stop. Here, section 163 says, return with, that is any accretions that take place. Suppose a cow is bailed. Cow is given to you on bailment for your personal use. And also, the question is, any accretion occurs. Suppose the cow gives birth to a calf. Then, along with the cow, when you return, the calf also has to be returned. You cannot say, sir, what has been given, possession has been given to me is only the cow and not the calf. Please remember, at that time, the cow was not pregnant. Later on, it became pregnant and gave birth to a child, gave birth to a calf. And that's an accretion. That is an addition. That is a addition to the goods already bailed. Then in that case, along with the goods, the accretions or the additions also has to be restored back to the bailer. I think with this we shall stop, and tomorrow in the next class we will deal with the rights of the bailee, duties of the bailee, and then the other consequences. Then after that we go to the law of pledge or law of pawn. Any questions, please? Any questions? Any questions by way of interaction? Yeah, I can answer you only when you ask. If you do not ask, I deem it that you have understood everything. So in the next class, the bailment will be continued. Thank you very much.